I have a letter dated March 9th, 2016, addressed to the Honorable William P. Cole, President of the West Virginia Senate. Dear President Cole, pursuant to the provisions of Section 14, Article 7 of the Constitution of West Virginia, I hereby disapprove and return the enrolled committee substitute for Senate Bill 10. I am advised that this bill is overbroad and unduly burdens a woman's fundamental constitutional right to privacy. See Planned Parenthood of Southeastern Pennsylvania v. Casey. Among the bill's prohibitions is a leading pre-viability medical procedure, the dilation and evacuation method that, for reasons of patient safety, is preferred by physicians. The Supreme Court of the United States and the United States District Court for the Southern District of West Virginia previously struck down similar overbroad laws that unduly burdened a woman's right to choose this procedure. See Stenberg v. Carhart, Daniel v. Underwood. Declaring sections of West Virginia Women's Access to Health Care Act to be unconstitutional. Ban at issue encompassed the common dilation and evacuation method, and thus unduly burdened a woman's constitutional right of privacy. In these circumstances, a veto is appropriate. Sincerely, Earl Ray Tomblin, Governor.
Message be received. The Senator from Jackson.
Thank you, Mr. President. I move that in accordance with Section 14, Article 7 of the Constitution of the State of West Virginia, the Senate proceed to reconsider Senate Bill 10, heretofore disapproved and returned by His Excellency the Governor with his objections.
Senator from Jackson moves in accordance with Section 14, Article 7 of the Constitution of the State of West Virginia, the Senate proceed to reconsider Senate Bill 10, heretofore disapproved and returned by His Excellency the Governor with his objections. Is there discussion? If not, the question is on the adoption of the motion by the Senator from Jackson. All those in favor will say aye. Opposed, no. The ayes have it. I declare the motion adopted. The question now is on passage of the bill, notwithstanding the objections of the Governor. Is there discussion? The Senior Senator from the 17th.
Thank you, Mr. President. Just real briefly, I'd like to rise in opposition to this. And quite honestly, a second trimester abortion is something that's troubling to most of us, and myself included. But this bill, just understand what we're doing here. This bill has been passed in 2 states, enjoined in both states. This comes on the heels of us passing a clearly unconstitutional abortion restriction last year that hadn't been challenged, so it's still law, but there's no question it's unconstitutional. This one is arguably unconstitutional as it's been enjoined in 2 states where it's been tried. But beyond that, it just doesn't make any sense. I mean, what we're doing with this is we're saying that the safest procedure cannot be used, and I know it's a troubling procedure to think about it, but it's the safest procedure that doctors can use with women who want to do this, and we're requiring them to do the less safe procedure, which has been told to me by an OBGYN in some situations is not even possible. We're requiring them to do the more dangerous, more difficult, and in some circumstances, the impossible with this. So it just, to me, and again, we're slapping the governor again and not respecting the governor's vetoes, which we're pretty common around here these days. But it just, to me, doesn't make any sense for us to do this, so I urge rejection.
Is there further discussion? The Senator for Boone.
Thank you, Mr. President. I again rise in opposition to this as well. We've heard clearly from the medical community that this is the safest procedure and frankly the only procedure that's available to do this second trimester abortion. So there's very few second trimester abortions to begin with. There are conditions where someone, frankly, may not even know they're pregnant until they're in the second trimester. And those same people, perhaps are quite overweight, are the ones that's the most difficult to inject something into the uterus to euthanize the fetus prior to this only procedure available. We are Again, it's going to be considered unconstitutional in the 2 states that it's been happened already. I don't know why we have to do something like this that takes away basically abortion in the 2nd trimester. That's what we're doing here, and I urge rejection.
Senator from Marshall.
Thank you, Mr. President. You know, I don't think it's any secret that I've had a long history of being pro-life in this chamber in my last 19 years. And that's been guided in many instances by recognition of 3 principles. Number 1, that under the law, abortion is legal. Number 2, it should be rare. And 3, and equally important, that it should be safe. You know, I have supported, sponsored, and voted for legislation in the past that have provided, you know, unborn victims of violence protections for women who lose their pregnancy to act of violence and hold those folks accountable. Informed consent to give women additional information, particularly as to alternatives as they make that difficult decision, that other adoption and other agencies might be available to for them to consider. That, you know, even the ultrasound bill that was accused of being mandatory, it was merely, as it passed this Senate, basically gave a woman additional medical information should she so choose to avail herself of it. But I've also been guided by the fact that any type of information that we were providing in any bills we passed also ensured that there would be no criminal penalties against any woman making that difficult, horrible, and gut-wrenching decision, nor to provide that any of the medical providers that are assisting the woman in carrying out the legally permitted procedure would suffer any criminal penalties as well. You know, I listened to the speech 2 weeks ago, or a few weeks ago, of the senator from Boone. And after hearing his comments, I had occasion to do some little bit of research of my own concerning this procedure. And I am concerned that the D&E that is permitted is in fact the safest and medically accepted procedure of choice to perform these 2nd trimester abortions. I'm concerned that if we pass this bill in its present form, that we will now be making illegal the safest procedure available to the medical community. I also am mindful of the fact that we passed last year the 20-year pain-capable bill, with recognition that at 20 weeks a fetus could feel pain. I guess the flip side of that is up to that 20 weeks, there is no pain being felt by the fetus. And I'm concerned that what we're doing by this bill is in that 2nd trimester, beginning with the 12 weeks to the 20 weeks. When under legislation we have passed, there is no pain. That we're going to force a woman to undergo a less safe medical procedure in order to proceed with the termination of the pregnancy. I just stand here today and tell you that under those 3 guiding principles of while it's legal, it should be rare and should be safe, I am extremely concerned that by passage of this bill, that we will be ignoring the safe principle, and secondly, making illegal the safest method known by medical science. For that, Mr. President, I cannot push the green button on this bill in this override, and I would urge others to do the same.
Further discussion. Senator from Ohio.
Thank you, Mr. President. I had no intention of speaking today, but after hearing some of the comments, I think we need to clear the air on a couple of simple things. I think everyone in this chamber can agree that a D&E is the safest procedure during a second trimester abortion. I will concede that. I'll agree with that. But I think we need to, it sounds like we're dancing around a little bit what it is. So I'm just going to explain. When we talk about a D&E, we're talking about ripping an unborn fetus part by part in order to cause death and create the abortion. What we're doing in this piece of legislation isn't prohibiting the safest procedure, the D&E procedure, but just saying that demise of that fetus should be caused prior to performing the procedure, so that child doesn't have to go through that horrific experience. And I get the gentleman from Marshall was talking about unborn pain and when they can feel pain. In the Health Committee in the Senate this year, we had medical experts testify, and one of the questions that was raised was, can you say with absolute certainty that fetus cannot feel pain at that point in their growth? And the gentleman who was testifying, he was speaking against this legislation, said he cannot say that with absolute certainty. So what we're talking about here is rolling the dice on whether or not that unborn child can feel the procedure, ripping them apart piece by piece. And I think when you look at it in that light, I don't see how you cannot support this legislation. Thank you.
Further discussion? If not, question for the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine and ascertain the results on this question. 25 yeas, 9 nays, 0 absent, not voting. More than a majority of those elected to the Senate, having voted the affirmative, I declare the bill passed, notwithstanding the objections of the governor.